So we will start from topic 5, Conduct of Homicide. So that include murder and manslaughter. And you will know what are the elements of murder. Elements of murder are?
Mental element, physical element.
Yep, so actus reus are act or omission to act cause the death of a human being. And then mens rea is intention to kill or intention to cause grievous bodily harm or reckless indifference to human life or constructive murder.
So 4 things.
Yes.
Intention to kill. Second, intention to cause grievous bodily harm. Fourth one,
Reckless
intention to
indifference.
be reckless indifferent to human life. Fourth one is
Constructive murder.
constructive murder, which that means you have a foundation offense like, for example, robbery, and in the course of robbery, someone is get killed. So someone is dead in the course of foundation offense. That means constructive murder. Yeah.
Okay, so when you talk about the actus reus, because it's about an act or omission to act to cause human life, death of a human. And when you talk about the actus reus, you need to see whether the act is voluntary and whether the chain of causation has been broken. So when you talk about the voluntary act, what is the key case for voluntary act?
Well, let's define what does it mean, what voluntary mean.
And the case tells you.
Okay.
Because you look at it as a voluntary act. You don't just look
definition
voluntary.
of voluntariness.
Act. Yeah,
So
exactly.
Which case tells you Ryan case?
Yeah.
Ryan case defines the meaning of voluntariness. Voluntariness doesn't mean, like in Ryan case, when you grab a gun, you load it, you level it, you point to the person, you cock it. All means you're doing with will, conscious will. These 2 words, conscious will, is the most important part. Defines voluntariness. Last moment, your muscle jerks or doesn't jerks is irrelevant. Most people misunderstand voluntariness means pulling the trigger. No. Voluntariness, this is the whole package of conscious will that you grab a gun or whatever, point, cock it. That's how voluntariness is satisfied.
So simple, you can say the series of action.
Yes, series of action.
Are done under a conscious and voluntary will.
Yes.
Then the court was saying that reflex action, not necessary, and involuntary act. And there are other case also work with this, which talk about the reflex action and the series of action, which is?
Reflex action series. Do you guys remember anything?
Is that Katazinski? Yeah, that's it.
Yes.
Katazinski.
Yes.
So that's the same thing where, he was saying that, oh, you're not that person.
Lunged at him. And that he's saying that he reacted to the lunging, and that's what made him. He tried to argue that he pulled the trigger 3 times in quick succession, but he said it was a reaction to what he said. Like a reaction, like a reflex action in the person lunging at him.
Another case was 2 guys. They went from hotel or bar to his place. Then he goes to a room. Other person sitting in the living room invites for a fight.
And they were both intoxicated.
Self-induced intoxicated. The guy grabs a gun. He said, my intention was to go and scare him and ask him to piss off. But something hit my head and I shoot. So my action was not voluntary. Which judge says, no, definition of voluntary is not who shoots why. Definition of voluntary is conscious will, that you grab a gun, load it, go there, point to the person. So I am satisfied your action was voluntary.
Yeah.
And also Falconer is also under voluntary conduct. But of course, she raised an effective self-defense. But we will talk about that later.
Yes.
But because that's also about shooting. and they will talk about whether it's a voluntary action.
Falconer was the one wife used insanity. Falconer was the case.
Automatism.
Automatism.
Is that the one where she woke up and
Yes.
found?
Yes, total dissociation, not partial dissociation, total dissociation.
Dissociation of a state of mind.
And she said, "Oh, I woke up. I didn't know that I've killed someone."
Falconer is.
Falconer.
Yeah.
Repetition. Falconer.
So she
But you
woke
don't need
up.
to remember the name. As long
I
as
remember
you
the facts,
say,
yeah.
as long as you say total dissociation of that case, they would know which one. They're kind enough to give you mark.
And so, in the list of the cases, they are all related to gun shooting. And all the defense would say that, oh, you know, I didn't do it, it's a reflex action, whatever. Then just cite Ryan and cite Katerinsky where the principles are the same.
Oh, yeah.
Just use that simple ratio, which is the series of action that cause death are under conscious will and voluntary will. Reflex action is not necessary an involuntary act, full stop. Then you cite Ryan, Katerinsky. Same principle, they share the same.
Established. Voluntariness of the death or manslaughter is established.
Then after you talk about the voluntary conduct, then you talk about the causation. Now, how do you understand causation in this context?
So, one is substantial and operating factor,
Cause, yeah.
cause,
As long as
without intervention, without substantial intervention, not to break the chain of causation.
yeah. So the key word is operating and substantial cause. As long as they establish and satisfy the cause of death is an operational and substantial cause, then the chain of causation is completed.
So
is that, go on.
So then when you talk about the case, one of the key case is Royal. Do you remember Royal?
Is the one that comes to my mind, I might be jumping, is the one where their Jeep or car gets stuck in the sand and then they
You're
start
close, not that
arguing.
one. You're close, but not that one.
Royal is the one that the murderer or accused gives out his story saying that I opened the door violently, she just jumped out and killed herself. But
Jump out the window.
Jump
She
out
jumped
the
out the
window.
window.
The balcony.
But the most important part is one is test, subjective test, objective test, natural consequences test, and there was one more test.
Okay, so yeah, in this case, the court used 4 different tests to test whether there is the change of the chain is broken. Number 1, same, operating and substantial cause test. Number 2, natural consequence test. Number 3, reasonable foresight of consequent test. Number 4, intervening test. As long as you can mention these 4 tests, just say the court used 4 tests to test whether the causation has been broken.
So can you
Cover
repeat
the
the test
causation.
again, please?
Yep, no problem.
Cover the causation.
Operating and substantial cause test, natural consequence test, reasonable foresight of consequent test, I will explain this later, intervening test. Now, with these 4, the first one, you always use operating and substantial cause test, which is
Moffat case? Moffat?
yes, but what it means is what caused the death.
What is the operating and substantial cause of death? There was a case, guy grabs the hammer, suffocates, of course self-induced intoxication.
They talk about pre-existing medical.
Yeah, in that one, judge come and the person says, the victim has pre-existing medical condition. So judge says, yes, he had, but in my point of view, the operating and substantial cause of death is what you did.
The
with
hammering.
suffocating the person and hammering him in his chest. Yes, he had a medical condition and you knew it, and that makes it even worse.
There was a trigger.
Yes,
Mm.
and you knew it. You should have looked after the person more, how vulnerable the person is. You failed to do it. So that's one of the things Joe is mentioning, that operating and substantial cause of death is the most important part.
So, regarding Moffat case, which is the pre-existing medical condition, my ratio that I have is pre-existing medical condition makes the victim more susceptible to death, but does not affect the test of causation. This is the ratio. That makes sense, isn't it? So you can argue whatever, he had a heart attack and he died. Yes, he did. But heart attack was just pre-existing. He had it anyway. But if you don't ham it with a hammer and suffocate it, he wouldn't die.
Same as Blau. One of the religion that there's a religious view they don't do blood transfusion. Yes.
The Seventh Day Adventists, is that the one?
No.
Something like that.
Jehovah Witness.
Oh, is it Jehovah Witness?
The judge says yes, the person didn't let to do the blood transfusion, but from my point of view, I don't care what you think. My opinion matters because I'm the judge. If you didn't stab the person that badly, the person wouldn't die.
Yeah.
Or wouldn't be in the position need blood transfusion, isn't
Wouldn't
it?
need it. That's right.
So which cases just case?
Blau.
Blau.
So that doesn't matter. You just refer to Jehovah Witness case.
Yeah.
Or blood transfusion.
Jehovah Witness,
Yes.
blood transfusion.
Yes.
Then now go back to the case that you mentioned.
That was the one where there was two men and their car got stuck in the sand.
Yes.
And they started arguing and they got into a scuffle and a fight, and one of them was left on the sand, but he said that he then, and the other person then went away to cool off, and by the time he came back, he found the victim, or the victim deceased, in the water, and he drowned. But he tried to say, I think he called for help. By the time they got there, it was too late. But what he's saying is that he's saying it was the tide coming in. He tried to argue that it was the tide coming in that caused him to drown. But the judge said no, because there was no break in the causation. So it was a continuous act, a continuous.
The chain of causation is
not
broken. The chain of causation was not broken.
Exactly.
That's the wording.
Yep.
Yep.
So, as you exactly mentioned, so the person can argue, yes, a million things, but judge says, in my opinion, this is the point, judge's opinion matters. Other people's opinion doesn't matter. So judge says, in my opinion, if you didn't do what you did as a whole test, the person wouldn't be in that position to die. Same as Blau. If you didn't do what you did, the person wouldn't be in that position to die. So then I found you guilty of murder.
What was the name of that case with the two men in the sand?
Pallet.
Pallet, that's it. Pallet.
There's one more case you can talk about, the causation. Burns.
Burns, yes. It's very important case.
Burns, I know that one.
Drug injection.
Oh, so he went to buy drugs
From the couple.
And the couple tried to say that they did not. They sold him the drug, but they didn't inject him with it. That he had ingested the drugs himself, and apparently he had an episode. He died. I think he might have been in the back of
Still in their property.
He was on their property. I think in the
Bathroom.
bathroom chambers or something at the back, and he died. And again, they called the police and ambulance and whatever. But by the time they got there, it was too late. But what they're saying, I think they got off on the fact they were acquitted. Is that right?
But how does it link to causation in the causation sense?
They're saying that they were okay because his defence was saying that they had caused him to die by giving him the drugs, but they got off by saying, no, he injected the drugs himself, therefore he caused his own death.
And
So-
he overdosed.
And he overdosed.
In this case, it's the intervening then, because
The
the
chain is broken.
what happened, what is the operational and
The cause
Substantial
of the
cause?
death is
was the injection.
overdose of.
But was it by the first person who sell the drug? No, was the person himself. So see, there is no chain of causation there.
Yeah.
In trial, police argued that no, you have injected
Yes.
it, sold it,
That's why they convict them
injected
in the
it,
trial.
overdosed it. In
Appeal.
the
The
appeal,
appeal.
they trusted that no, I only sold it. Then he left. We were under the impression that he left to go to leave, but somehow either he came back or he didn't fully leave. He just said somehow stayed in the property and overdosed it himself.
Yeah.
Then he died. So I only sold it. I didn't do it right. That's illegal and illegal
That's
act.
later.
But that's irrelevant to kill a person. I have no
In terms of causation,
causation of the death. I have done nothing. And judge accepted and he walked as much as I done.
But you will be charged for another?
That's another case,
Yeah.
but not for murder.
Not for
yes.
murder.
Not for murder. Then you pretty much have talked about most of the cases. Like, I mean, it's still, have Smith case and Jordan case, but still, when you talk about the causation, you just make sure you mention what is the operating and substantial cause of the death, and was the chain of the causations broken.
Others three tests are.
Those are only for royal.
Yes,
Natural-
but in general, in causation, if you know these four tests,
Well, you
you
use it
almost covered the whole causation. Any causation you can argue, which is substantial and
Operating.
operating. Second
Cool.
one is natural consequences test.
Reasonable foresight of
We
consequences.
always do with natural consequences test. If you punch the person, fell on the floor, would the person die by that? No. Natural consequences test. So what else?
Intervene.
Intervening test. That's what they argue. There was an intervening factor. High tide kicked in. Well, judge says yes, it's kicked in.
But
But
it's not
if you didn't do what you
Did,
did,
he
the
wouldn't have
person
been
wouldn't
there
be
in
in
the
that
first
position
place.
to die. Or the person had a medical condition, but if you didn't do what you did, the person wouldn't die.
Yeah.
Fourth one is
Oh, you already talked about all of them.
the first one was with reasonable,
Reasonable foresight of consequences.
yeah, reasonable foresight of consequence. The leaving the person next to water, which water always high tide.
So do you need to apply all the tests?
So in the royal, it used all of the four tests.
Okay.
Yeah, tests.
So it's not necessary all the
No,
tests?
but if you know the four, you
You
cover
know
everything about causation.
Yeah, because most of the cases they cite royal, so which means they probably highly possibly look at all these tests.
Yes. Once the case they have well explained in a class, it's worth to read all about it.
And just cite it. Okay, so finish talking about the voluntary conduct and causation. Now, then you talk about the omission to act.
Yes.
So when you talk about omission, is omission to perform a legal duty to preserve life. So very important key term here is the legal duty. If you have not established a legal duty, then highly likely that omission of to act cannot be established. And many cases here has defined what mean by legal duty.
Which tactic case is the leading authority.
It's the leading.
Why? Because it defines you must have a legal duty. Grossly, if you're a doctor or medical practitioner, someone is dead and you grossly broke your legal duty, yes. But if you're not a medical practitioner, and you are a blood related, like a case was an anorexic case. The girl.
Stone and Dobson.
The girl, Stone, hires the brother and the brother's wife to give her care. She hires them to look after her. And they somehow let her to die. Then they say, well, we don't care, we shouldn't be charged. And judge says, one, you're blood related. Second, you've been hired to look out for her, and you grossly failed to do so, and that's why she's dead. Another case is Tak. Tak case, he brought two prostitutes. All were taking lots of drugs. One of the prostitutes takes so much and she gets into bad mood. He jumps to help. This is one point.
Took her away.
He stops other people to call them for ambulance and medical help. These two are the most important part. Judge says you have established assumed duty of care to that person by jumping in and helping and stopping other people to give help.
And he took her somewhere else, didn't he?
Yeah, so
she did something.
like he took her into in a room. There is only two of them. So in that sense, then you're actually stopping other people who will be able to help. If they saw, what happened? They can call ambulance or they can do something about it. But if it's just only you and that victim in there, okay, no one else knows there is something wrong.
Yeah, so the person dies, but the reason he gets off is because report comes and says she had too much combination of drugs, even ambulance got her, she wouldn't survive.
She had already OD'd.
Yeah.
Yeah.
So,
but it's a hard one, this one too, isn't it? Because sometimes they say the people will die and the people survive, so it's
medical test came and said extremely overdose, that she wouldn't have survived nowhere on the planet.
But nobody knows.
Yeah, so then he gets off.
Yeah.
okay. And then now the next case, you already mentioned Stone and Dobson.
Yes.
So that is to talk about gross negligence. As long as you talk about gross negligence, it's not just negligence, gross.
It's not normal negligence, gross.
So the principle I have for Stone and Dobson, gross negligence, a high level degree of duty of care, fail to act to prevent death. So it's completely fitted the title. It says, omission to perform a legal duty to preserve life. And both are convicted. The husband and wife are both convicted. Okay?
That Russell is one?
That's Stone and Dobson.
I don't know.
Now,
Another case.
Now Russell is actually talk in the defense as well, defense topic. I don't know if you remember. This is the case where he just watched the wife and kids drown.
That's his story, that's not the reality. He makes up the most stupid story on the planet.
So I just stand there and watch.
He says his two kids died, his wife is dead. They found him
he was
accused, and he says, no, I just watched my wife drown the first kid, said, would you care? I just stood and watched. I haven't killed, I should go home.
He says he didn't even say anything.
Yes, then my wife said, I'm gonna kill the second one. Would you say anything? Then I didn't. Then my wife said, now I'm gonna kill myself. Would you say anything? No, I didn't. Then I think judge and jury were saying, do you really think we are that stupid?
To let you walk.
But I guess he used
to believe your fucking story.
He used the defense of insanity. Like, he was mental.
Yeah.
But he's not successful with that.
The story was too stupid.
Wouldn't say stupid, but it's just really up to the jury and the judge whether, they...
I mean, too stupid to anyone to believe.
So now, in terms of that, then with the duty of care, you believe so. It's a totally legal duty. Why is that? Husband and wife, parent. this is a high degree of legal duty.
Like
Presumption is you must perform your legal duty.
To preserve
You
life.
can't say I didn't do because I didn't feel like doing it. So fuck you.
And that's why it says omission to act, because he didn't do anything, he just stood there. So it says circumstances where omission may amount to murder. That is the case, Russell.
Okay.
You can mention another case, which is Taba and Steinman. That's where two men go and rob a woman that sell drug, and they tie her up and then they beat her so badly, and then before they left, they called the police. Taba, and Steinman. Yeah, Tabor. And so she died from dehydration. Before the ambulance came, she already dead. So this is circumstance when killing by omission, again, may amount to murder. That's the principle.
Repetition of the causation. They said we just left her there. We haven't killed her. Judge, look at the causation. Would the person die if you didn't do what you did? No. Is there any intervening factor in causation? No. Like, it's not there was an earthquake and she died. No. And if it was another scenario, why she was tied up? So there is no broken chain of causation, then she's dead.
Okay, so that's end of topic 5.
And also that can be discussed in constructive murder. They were doing a robbery.
And death occurred during or immediately after the foundation offense.
You see? So, Ryan case, robbery, and another case was Hitchens case, taxi driver. They robbed the taxi driver and they let him to die and he's dead. So why this is so important, this constructive murder? Because it's so easy to convict him for murder. Why? Because they don't need to establish
Any mental elements.
It's easy to establish there was a robbery, so easy to establish that.
And if there's a
And
death,
someone is dead, I don't care the mental element to establish, and you're gonna raise me a defense of all these 3 things, and then I'm gonna argue back, and immediately police murder, go for life. You see the importance of this one? That's why, if you notice, all the examples that they use for exam, one way or another, is bridges between larceny, murder, assault, and murder. So because this covers all, covers, yes, causation, covers mental elements, involuntary, voluntary, and all these things.
So yeah, I found that once you understood individually, then you can cross-use them.
So I guess what you understand, if you can use what you learned from this session, you can easily get 20 marks.
So do you think it's one question, yes?
This area that covers big area of the questions.
So, okay, then I will...
So can we revise it?
Yeah, definitely. So, okay, now I'll make it short and simple.
Yeah.
Alright? So, if you look at your outline, topic 5, conduct of homicide. Now, there are something I haven't talked about yet. I'll come back to it. When you talk about homicide, make sure you talk about Section 18 of the Crimes Act. You make sure you have to talk about Section 18 of the Crimes
Get
Act.
mark for it, don't lose it.
And then the elements of murder, actus reus, act or omission to act, cause the death of a human being. Then mens rea, intention to kill or intention to inflict grievous bodily harm, or reckless indifference to human life, or constructive murder. You have to write it all in your exam. If you talk about murder.
So the physical element is that someone dead.
Yeah, act or omission to act. Those are the actus reus.
Okay.
Then when you talk about the actus reus, because it's act and omission, isn't it? Act or omission. Then now, when you talk about the act, you need to say, was it a voluntary act? Is the chain of causation broken or not? Then, when you talk about the voluntary act, you make sure you talk about Ryan case.
Because you need to define elements of voluntariness.
And in this case, it tells you that the series of actions are done under a conscious and voluntary will. You have a reflex action, not necessary, an involuntary act. Yes, yeah.
Royale.
Then Katerinsky, same thing, shooting, yeah. And he used the same defense as, I just have a reflex action. All right, cite Ryan again. The series of action is voluntary and conscious. Reflex action is not necessary and involuntary act. Falconer, same thing, yeah. But she had a defense, all right. So we talk about it later. Then you talk about the causation. Did the chain of causation break? Now, how do you define causation? First, you can cite Royal case, because Royal case tells you there are 4 tests to test the causation. Is it broken or not? There are operating and substantial cause tests, natural consequence tests, the reasonable foresight of consequent tests, and intervening tests. So these are the 4 tests used in Royal. Then now, you can talk about other cases. For example, Hallett. Okay, they were saying that he was died from drowning. Then the court says, what was the operating and substantial cause? It was you hitting him and he was unconscious and causing really grievous bodily harm. Then the high tide drowned him. Well, the intervening cause wasn't breaking the chain.
If you look at it as a whole, the key is judge looks at it as a whole.
From
if
initial.
you didn't do what you did, would the person die?
Another one, Moffat. Now, Moffat, then you relate it to pre-existing medical condition. Now, what happened here? He was arguing that he died from heart attack. But what he did, he hit him with a hammer and suffocated him, right? Then the court was saying, this is the ratio. Pre-existing medical condition makes the victim more susceptible to death, but does not affect the test of causation. The chain hasn't broken. The initial chain operating in substantial cause was you hitting him with a hammer, suffocating him.
Which was the one that failure of medical help does not amount to breaking chain of causation?
Smith case.
Smith case.
Let's
be I tell you what. Smith's case was the police officer jumps into the front of the car while the truck guy is trying to escape, and the guys swearing whatever, and then the police officer gets called to the hospital and gets medical help assistance, but he dies. His defense was medical help wasn't good enough. It was grossly low quality, and judge says, from my point of view,
incompetent medical treatment will not break the chain of causation.
No matter how grossly they did a bad job, from my opinion,
incompetent medical treatment will not break the chain of causation. Then, also, you can talk about Burns case. Burns case is where the couple sell drug. But what happened here? Chain of causation
was broken.
Yes, was broken.
Because he ingested the drugs
himself. And they sell the drug at the first place. That was the first initial cause. But then the deceased did it himself. So see, the chain was broken by the victim himself.
So they had no control over it.
Yeah.
The person could not do it like million other people. But he overdosed it.
Yeah. Then now, you move on to talk about the omission to act. We just finished act, yeah? Now we talk about omission to act.
I remember when you asked the teacher about the case that they stabbed and leaving there to
Die.
die. He said that you take the victim as you
found
found them. Yeah, I remember this.
Yes, that's the key actually. That's the sentence. You leave the victim as you found them. Means the person, whoever it is, whole purpose test. Would the person die if you didn't do what you did? You leave the victim as you found it.
I remember what that said. Yeah.
That's a better way of saying whole test.
You take the
You leave the
You
victim
take
as
the
you
victim
found.
as you found them.
you take the victim as you found.
You leave the victim as you
No,
found.
you take.
You take.
You take the victim and leave the victim as you found. Anyhow.
Then okay, once you, if the act is omission to act, then you talk about other cases that is related to omission to act. Now, importantly, with omission to act is omission to perform a legal duty to preserve life. Then there are cases is talk about what do you mean by legal duty. Then in Takta case,
Takta case, there was a presumed legal duty.
Presumed.
Volunteer presumed legal duty, one. Second, stopped other people from giving assistance. Because there was a presumed legal duty and he grossly fell short by stopping other people from giving assistance, he was charged with murder. But he got off because medical report came that she was extremely overdosed and cocktail of the drugs. No way on the planet she could survive. Even that moment, ambulance and full medical test would help. So that's how he gets off.
Then another case, Tabor and Steinman,
Yes.
where they robbed the lady, left her there, she died from dehydration. Now, same thing, they left her, so there was an omission to act. Then circumstances like that, when killing by omission, may amount to murder. That's it. Another two cases that are blood related. One is Russell, where he just watched.
It's 7 o'clock.
Where he he just stood there and watched the wife and kids drown.
Yeah, I failed to say, even judge says you stood there and watched them. Let's say we believe your story, your stupid story, but you have a presumptions that your duty, you have a blood related, your duty was to care. Even if we believe your stupid story, still you are convicted of murder.
You have to. Yeah.
Both ways, you are convicted.
So in this sense, easy, because of the legal duty, and he failed to act to preserve life. That's it. That's the ratio. Stone and Dobson, same case. Not same case. A similar scenario. So they had they were a couple, and the sister was the lady was the sister of the husband.
Anorexic.
Yeah, and she had anorexic.
And she hired them to look after her.
So in this case, they are blood related. Again, there is a very high degree of legal duty between them.
One is blood related, and the one is she has hired them.
The high level degree of duty of care, and therefore it was gross negligence of both of the husband and wife to take care of her, and they failed to act to prevent death.
Yes. So the wife wouldn't be charged with murder if she wasn't hired to give that duty of care. Husband, yes, was blood related, but the sister-in-law wasn't blood related. The main reason she got charged because of she was hired to care for the anorexic girl.
In that sense, that's end topic 5.